In light of the tension between the police and the public in many cities across the nation, it's crucial that people, especially young people, know and understand their rights. So in this video, I will answer a commonly asked question concerning your legal rights when interacting with the police. Christian attorney Ariel Johnson, lawfullife.us. If you're new to this channel, my aim is to make the law accessible to real people. So if you like the content, please be sure to subscribe and to click the notification bell so that you will not miss any new content. Can I question the cops if they arrest me? The short answer is yes, but the time and place for questioning is probably not the moment and location of your arrest. You may ask why. If I'm not under arrest, can I just walk away? Yes, you could, but that's ill-advised because you don't yet know why the officer stopped you or what the officer may know that you don't know. Now, law enforcement must have a reasonable suspicion to conduct a stop and frisk. These are sometimes known as Terry stops, and I'll address them momentarily. Again, the problem with just walking away is that you can't know whether or not the officer has a reasonable suspicion or not. If that officer does have a reasonable suspicion, then that officer is justified in forcibly detaining an innocent person who simply tries to walk away from an interview. So before just walking away, politely tell the officer that you don't want to be interviewed and ask if you're free to go. If the officer says that you are not free to go, stay there, remain calm, and make a mental note of everything that's said or done so that you can sort out the legalities of the incident later. If you were injured, seek medical attention right away so that you can document those injuries. Incidentally, as long as a police officer does not imply that you're legally required to comply, a police officer does not need a reason to suspect that you've done anything wrong in order to approach you, ask questions, and or to ask to search your possessions like your backpack or your purse. Also, if the police do decide to arrest you, it's only because either they have a warrant for your arrest, that is, written permission from a judge, or because they have probable cause, meaning a strong, unbiased, factual reason for believing that you have committed a crime. So because only a judge or a jury can convict you of a crime, you're far better off cooperating and protesting your innocence in court, not during the arrest. For this reason, once arrested, it's better to remain silent at the time of your arrest and let your lawyer ask all of the questions later. Indeed, the rule of thumb for anyone stopped by the police is to keep both of your hands in plain view, remain calm, cooperate with the law enforcement officer's commands, let the officer ask all the questions before volunteering information. For example, you don't want to be heard saying, "Yes, officer, I know I was speeding." Also, don't argue, don't resist, don't run, don't obstruct the officer, even if you believe your rights are being violated. Also, do not consent to any searches. And if you must talk during arrest, let it be to ask for a lawyer. A related question is, can I find out about the police officer that arrested me? The answer is yes. This is done during the process known as discovery. And as I'll explain in a moment, the discovery process is where the government must reveal to the defense information that casts doubt on the credibility of the police. But more specifically, discovery refers to methods used by parties in a civil or criminal action to obtain information held by the other party that is relevant to the action. There are several sources of law that govern discovery in criminal proceedings, but generally speaking, here are the key provisions. First, there are the established procedural rules of the presiding court. For instance, in federal courts, upon request, the defendant may discover 5 different types of information: written records or statements made by the defendant and in the possession or custody or control of the government, any prior criminal record of the defendant in the possession of the government, documents and tangible objects in the possession or custody of the government that are material to the defense and intended for use during its case in chief, and that is the main, primary, and best information and evidence that the government intends to present at trial against a defendant, examination and test reports in the government's possession that are material to the defense or intended by the government in proving its case in chief, and a written summary of expert testimony the government intends to use during its case in chief. Then there's the so-called Brady Material. According to the United States Supreme Court's 1963 decision in the case Brady v. Maryland, the prosecution has an absolute duty to disclose before the trial any evidence that may undercut its case. This undercutting evidence, which is known as Brady Material, includes anything that could help an accused person's defense. Brady Material includes, but is not limited to, evidence that someone else confessed to the crime, evidence of a witness's prior inconsistent statements, evidence of a witness's motive to lie, and information that casts doubt on the credibility of the police or the crime lab. As a matter of fact, in California, a defendant in a criminal case can file what's known as a Pitchess motion. A motion is an application to the court for relief. So with a Pitchess motion, a defendant requests to inspect a police officer's personnel file for evidence of police misconduct whenever the defendant suspects that an officer may have acted improperly. Now let's talk about some specific police powers related to stops, searches, and arrests. For stops, the rule is absent a warrant, law enforcement must have a reasonable suspicion, meaning a clear, specific, and unbiased reason for suspecting that you have committed or are committing a crime. Law enforcement may also stop and question you because you are a witness, not a suspect. These are called Terry stops. I'll explain a Terry stop momentarily. Further, as it pertains to searches, the rule is that you must consent or the officers need a warrant, that is a document signed by a judge giving them permission to search you or your property. However, there are 6 exceptions to this rule. They are a Terry stop. In the 1968 case Terry v. Ohio, the United States Supreme Court told us that under the 4th Amendment of the United States Constitution, a police officer may stop a suspect on the street, frisk him or her without probable cause to arrest if the police officer has a reasonable suspicion that the person has committed, is committing, or is about to commit a crime, or has a reasonable belief that the person may be armed and presently dangerous. Now, after 52 years of litigation, the Supreme Court's holding in Terry remains the law of the land, but the practical implications of Terry deserve mentioning. As I mentioned earlier, as long as a police officer does not imply that you're legally required to comply, a police officer does not need a reason to suspect that you've done anything wrong in order to approach you and ask to question you or ask to search you or your possessions. Second, a police officer is not required to immediately tell you why you're being stopped. Third, an officer can ask you to get out of your car or to stay in your car. Fourth, an officer conducting a Terry stop may conduct a pat or frisk, but is not permitted to manipulate the contents of items under your clothing. Fifth, an officer may seize weapons or items of contraband if the nature of the items is immediately discernible to the officer from the pat down or frisk alone. Now, returning to the list of exceptions to the consent or warrant rule is the second exception. The second exception is a search incident to an arrest. The third exception is a vehicle search where the vehicle was probably used in a crime and probably contains contraband. Now, as used here, probably means insofar as seems reasonable, true, factual, expected, or without much doubt. There's also a community caretaker exception to the warrant or consent search rule. That is, where there's an articulated reason supporting the officer's conclusion that a citizen needed immediate aid. The fifth exception is the exigent circumstances exception, where the officer believes, for instance, that a suspect will probably destroy or run away with evidence of a crime. And the sixth exception is where an officer has reasonable cause to believe that a person on probation or parole has items in violation of the conditions of their probation or parole. Thank you for watching. If you find this content useful, please let me know what you think in the comment section, and let me know if you have questions or suggestions for future videos. Also, be sure to subscribe and hit the notification bell so that you won't miss any upcoming content. By the way, if you're looking for legal content that's accessible to real people, be sure to join us online at lawforlife.us, where we profess the truth that without God we can do nothing.